Hello and good morning everyone, and welcome to the Housing Development and Housing Management Update presented by the Social Housing team here at Burkitt's. It's fantastic to welcome all of you this morning, and I hope you find this update to be interesting, useful and insightful. What we've got for you this morning are a number of different topics designed to cover much ground in our world, the social housing world. We're going to look at the new shared ownership model lease, some ground rent reform detail, and my two colleagues, Sarah Fitch, a senior associate in the team, and Lee Stone, an associate in the team, will be looking at those two topics first. After that session, we'll be joined by Clive Adams, who is a partner in our social housing team, and the head of construction, Steph Harris-Wright, who's a partner who, between the two of them, will look at the Building Safety Act and also provide us with an update on the social housing regulation bill, essentially a peek over the horizon into the future from a housing regulatory perspective. After their contribution, Ian Rattenbury, who is a senior legal executive in our team, will spend a little bit of time taking us through some of the latest housing and asset management case law. And then at approximately 11:15 a.m., we'll have a Q&A session. And at that session, we'll be joined by Kevin Edwards, a legal director in the team specialising in property and non-contentious law, and also Catherine Hodds, who is an HR consultant with the team here at Burkitt's. So that's the Q&A session, which I will chair, and I look forward to joining you again then. Just one or two housekeeping matters before I hand over to Sarah and to Lee. Please put your questions in the chat function. I will see them as your host, and I'll be sure to put those questions to the panel at the Q&A session. And then also the session this morning is being recorded, and we will make sure that the slides are circulated to all attendees at the conclusion of our session. I would like to thank you again for joining us this morning. I do hope you find this morning's session to be interesting and useful to all of you. And so without further ado, I will hand over to my colleague Sarah, who will look at the new shared ownership model lease. Thank you very much.
Good morning. So as Jonathan mentioned, my name is Sarah Fish. I'm a senior associate at Burkitt's and I'm based in Norwich. I'm going to be looking at the shared ownership lease. I'll cover a few points which Lee will then take over from there. So although the new model shared ownership lease was actually introduced in May 2021, the trigger for mandatory use of the lease has meant that in practice it's not been used very often to date. What we have seen is a number of clients who have been using the new term under the lease with the existing provisions of the old lease. And this is really to ensure that leaseholders get the benefit of the new extended term, whilst the finer details in respect of other changes are being considered internally. So next slide, please. Okay, so the changes encapsulated into the new model lease, and whilst new providers are able to make amendments to this, any amendments cannot fetter the operation of the fundamental clauses unless you've got the consent of Homes England. So your fundamental clauses relate to the assignment, disposals where less than 100%, mortgagee protection now, and staircasing and rent review. So just to start with, I want to recap the key changes that were made. So this is the initial share reducing to 10%, the simplified 1% staircasing increments for the first 15 years. I've got the landlord responsible for repairs for the initial 10-year period. The nomination period on resales was reduced from 8 weeks to 4 weeks, and we've got the 990-year lease term was introduced along with the mandated key information documents. Next slide, please. So when to use the new lease? There are two routes for delivery. The first being grant funding. So the new lease applies to all shared ownership properties delivered under the new Affordable Homes Programme 2021 to 2026, or funded from the 1st of April 2021 using voluntary right to buy receipts under the voluntary right to buy programme. The second route is planning. So the lease will apply to all schemes where full or outline planning permission is granted after the 28th of December 2021, or where there is significant pre-application engagement after the 28th of March 2022. It's also important to note that these changes apply to homes in England, and that's excluding London. Next slide, please. So moving on to the changes, I'm going to discuss the mandatory key information documents first, as I know that there's something a number of our clients are trying to get their head around. So where the landlord is selling or reselling a shared ownership property, they are now required to provide specific information to potential buyers. It's likely that this is something that was already being done, but there are now the requirements as to the information that is to be provided. And the idea is that this is a view just to be completely transparent. So you've got the key information document 1, and this is a standardized information sheet designed to give the buyer all information on the outset so that they can make sure that a product is right for them. So it sets out basic details of properties available on the site, bedroom sizes, the type of scheme, market value, and any additional costs. The KID 1 will also include details of the amount of rent payable based on the percentage retained by the landlord, and it will contain details regarding eligibility and the fact that the buyer will have to register with a Help to Buy agent, and as part of the process of their application, it will involve consideration of their finances and their credit record. The landlord also has the option to add information in here about themselves, whether pets are allowed on the site and whether it's possible to 100% staircase at any point. So once the potential purchaser has been through the eligibility assessment, but before any formal reservation, they're to be provided with the key information document 2. And this is to include a detailed summary of costs, any service charges and potential costs. So this is not solely looking at the cost of acquiring the property, but any future costs, so costs later on in connection with staircasing, etc. At the same time, they'll be provided with the key information document 3, and this is to include further detail about the terms of the shared ownership lease itself. So this is quite a generic, but it will highlight whether shared ownership is a suitable option for the leaseholder. It explains how shared ownership works, the leaseholder's responsibilities, including details of what they can and cannot do. So it will also summarise the detail that they can expect to find in the lease in respect of acquiring more shares and selling the share in the property. Again, this is very focused on transparency. So this document also will include further details for finance, and this will focus on the rent and when this is to be reviewed, and also any potential increases, along with details of costs that the leaseholder would be responsible for, including reserve funds, management fees, and building insurance. So in relation to all of these key information documents, it's the responsibility of the landlord to make sure that these are up to date and they include all details that are relevant. A practice point to note here is that these documents are not only required to be provided to the purchaser, but also to their solicitor, who in turn has to confirm that they too have sent them on to the purchaser. Next slide, please. So 2 other key changes to the lease, as the first one being the lease term. So the old lease was previously 99 to 125 years, and the term under the new lease is to be 990 years, and that's with no exceptions. So this fits in with the government's agenda to reform leasehold ownership and to keep associated costs to a minimum. It was thought that the term of 99 years previously meant that leaseholders were having to pay large sums of money to extend their lease in the first 20 years, because having a lease with less than 80 years remaining on it made it much harder to sell. A practice point here to be aware of is any contracts for long leasehold properties where the length of the lease owned may not actually give you long enough to grant a lease of 990 years out of it. So the nomination period has also been reduced from 8 weeks to 4 weeks, and this means that provider only has 4 weeks to take assignment of the property. So if the property is not sold within those 4 weeks, it means the leaseholder is able to sell free on the open market. In theory, this shouldn't pose a problem for providers, but again, it just needs to be considered alongside any nomination requirements under planning agreements, nomination agreements. This is a lease condition and therefore would no longer apply once the leaseholder owns 100% of the property. Next slide, please. So a 10-year period has been introduced during which the cost of any maintenance or repairs will be met by the landlord rather than the leaseholder. The date of this is to start at the date of the lease, and it will end 10 years after that, or on final staircasing if that's sooner. So the benefit of the 10-year period can be passed on to future buyers within that time, but it doesn't restart on any resales. In terms of the repairs covered, these are split into two categories. We've got the external and structural repairs, and then the general and maintenance, and these are defined in the lease. The changes here reduce the likelihood of unknown costs for leaseholders, but it's obviously an issue for landlords in that these obligations will differ from those that they have in respect of rented units, market units, or other shared ownership stock. So consideration needs to be made as to how the obligations are actually managed on a practical level. There is also the additional financial burden, which will need to be factored into any cost analysis, as these are not repairs that they were previously responsible for. Next slide, please. So looking first at external and structural repairs, the lease defines this as being essential repair to the load-bearing framework of the premises, the external fabric of the premises, the service media forming part of, but not exclusively serving the premises, and all other structural parts of the premises, and which have been notified to the landlord during the initial repair period. And for the avoidance of doubt, the external and structural repairs will not include general maintenance, redecoration, and renewal works. So the lease expressly provides that any works which would be covered under a warranty or a guarantee are excluded, and where a claim could be made under either of these, that must be done in the first instance. The leaseholder has the responsibility to inform the landlord immediately of any required external and structural repairs, and they're to provide the landlord with a reasonable access to either enter the property to carry out the works or to enable the landlord to make a claim under any existing warranty or guarantee. The landlord is then to carry those works out at no cost to the leaseholder, including where it's an excess payable under a policy. That again falls on the landlord. So currently the lease is silent on what happens if it cannot be agreed between the parties as to what these repairs actually include. Next slide, please. So the second key amendment to the repair and maintenance provisions is in respect of general repairs and maintenance. So whilst the landlord is not responsible for general repairs to the property, during the 10-year period, the leaseholder may apply for a contribution towards any costs incurred for qualifying general repairs and maintenance works. So the leaseholder is to provide all information to the landlord to enable the landlord to assess whether the works qualify for this allowance. The landlord is then to consider any claim made and to notify the leaseholder of a decision within a reasonable timeframe. The amount available to the leaseholder is £500 a year in respect of these costs, and any unused money can be rolled over into the following year, but only by a maximum of £500. So if the £500 is unused in year one, that would roll over into year two. However, if it still wasn't used in year two, along with the second £500, out of that £1,000, only £500 would roll over into year three. The £500 is not index linked, and there's no limit on the amount of claims which can be made within that limit. The landlord has the ultimate say in whether these can be recovered and is to keep the leaseholder updated as to the remaining balance at the beginning of each year and also following any claim. A point to note here is that the yearly update is based on the date of the lease, and this is then therefore going to vary for every lease and will involve a robust internal systems to keep track of when these updates are required. Contributions towards sinking funds can be collected during the 10-year period, but they cannot be used in that time or used for anything which is deemed to be the landlord's responsibility. So the changes place a heavy administrative burden on providers as to how it's going to work in practice. So it's still something that is going to be figured out and is likely to be figured out over the following years and will vary from provider to provider. So next slide, please. I'm now going to hand over to Lee Stone.
Thanks, Sarah. So yeah, I'm just going to continue talking about some other features of the new model shared ownership lease, and then I'm going to briefly talk about the new Ground Rent Reform Act as well. So my name's Lee Stone. I'm an associate in the social housing team at Burkitt's. Can you go to the next slide, please? And I'm going to start off by talking to you about key changes to staircasing, which I imagine some of you might already be fairly familiar with, but there's quite a lot of content, so I'll try and get through as much of it as I can in as much detail as possible. So what are the key changes to staircasing? So the minimum initial share that shared owners can purchase has reduced from 25% to 10%. The previous model allowed minimum staircasing of 10% at a time, and the new staircasing provisions have reduced this to 5% via the normal route. The lease now also includes an option for more gradual staircasing, allowing shared owners to staircase by 1% each year for 15 years, and they can do that up to an additional share of 15% with their substantially reduced fees. To keep costs to a minimum, the new model requires the price of each 1% to be based on an estimated value linked to the original purchase price, which should then be adjusted each year upwards or downwards in line with house price indexes. The new 15-year 1% incremental staircasing option applies to shared ownership resales, also funded through the new Affordable Homes Programme. So the key question for housing associations really here is, I guess, how many people are going to take up on that offer, because it does have the potential to have large sort of administrative burdens, given that it's 1% staircasing, which is going to allow a lot more people to be able to staircase from an affordability point of view, which is what the intention is. Next slide, please. So just to continue talking about staircasing, shared owners can still staircase at any time during the term of the shared ownership lease. The 1% staircasing schedule contains a definition, which you can see if you have had sight of the new lease, of what that 1% staircasing period is. So it's a period of 15 years from the later of either the date of the lease or the date of assignment of the lease to a new leaseholder. And during this 15-year period, the 15-year 1% staircasing period, before each annual review date, the Housing Association must supply an updated 1% valuation annually, which is valid for 3 months. So again, it's more administration that RPs are going to have to deal with. If the staircasing hasn't been completed within 3 months of the valuation date, a new valuation must be provided, and house price index valuations are to be at the provider's expense. And the government has said that they do not expect those costs or any administrative costs resulting from the 1% incremental staircasing to be passed on to shared owners. So there's a clear intention here to get leaseholders to essentially get to a point where they can own more of their property, and the new programme is making lots of steps to allow this to happen. Next slide, please. So one of the new features of the shared ownership lease, one of the new features of the Affordable Homes Programme is the right to shared ownership. So again, this is something quite new, and given how new it is, it's quite difficult to get your head around as to how this is going to practically work. So these next few slides will talk about what the guidance is, which hopefully will make things a lot clearer. So the right to shared ownership. So what is it? So the right to shared ownership will apply to eligible new rented homes delivered through the Affordable Homes Programme, and it's a condition of grant funding. It provides eligible social tenants access to the new shared ownership model lease. So those who qualify will be able to purchase an initial share in their home of between 10 and 75% based on a RICS valuation, and the provisions of the new model lease will apply, including in relation to staircasing and repairs, and the new minimum term of 990 years. So essentially it's giving social rent and affordable rent tenants the ability to enter onto the housing ladder by taking a shared ownership lease of a property. Next slide, please. So the right to shared ownership will apply to all social and affordable rented homes built through the Affordable Homes Programme, except where an exemption applies. And exemptions are going to fall into 3 categories. So the first category of exemptions are where the property is exempt from the scheme. And we've detailed what these here on the slides, but there'll be things like local authority homes are exempt, homes that fall into designated protected areas and rural exemption sites. There's a few others which are detailed on the slide. The second exemption category is for those properties where the sale would breach the cost floor rule. So the cost floor rule is described as where the current market valuation is below the total amount spent on building or acquiring the property, including the amount of grant invested in the property. So based on that definition, I'm not sure how likely it is that that exemption is ever going to kick in, but it will very much depend on the region of the country, essentially, where the property is, which will relate back to what house prices are doing. The final exemption is where the property qualifies for what's been described as an exception. And these are situations where there are practical problems that would prevent a sale under the right to shared ownership, for example, where there are legal issues. So it doesn't go into huge amounts of detail on that, but yeah, perhaps where there's some litigation ongoing between a landlord and a tenant. I'm sure there's a fair few other examples as well. Tenants have a right to appeal a blocked application, and where an exemption applies, providers should offer tenants access to shared ownership of a similar property where possible. Next slide, please. So eligible tenants. So in order to be able to access the right to shared ownership, you need to have an eligible property, but you also need to be an eligible tenant. So let's look at that criteria and what that is. I've detailed them all here on the slide, but essentially to qualify for the right to shared ownership, a tenant must satisfy all of the following criteria. So they must live in an eligible property and must have lived there for at least 12 months. The tenant should hold an undermoted secure tenancy, an assured tenancy, or a Localism Act tenancy with a fixed term of at least 2 years. They must have been a tenant of social affordable housing for at least 3 years. This doesn't have to have been continuous or with the same landlord. They should not have rent arrears or be subject to bankruptcy proceedings or unfulfilled credit agreements, nor should they be subject to legal proceedings for possession or any other legal proceedings on the grounds of antisocial behaviour. The tenant must satisfy the standard eligibility criteria for the shared ownership scheme, such as income requirements, and they must satisfy any immigration requirements. So again, those criteria have just been placed, so I guess that to limit the amount of people that can apply. And I think the other key thing here is affordability, to make sure that those people taking a shared ownership lease can afford it, and that's what a lot of RPs will be looking to ensure, especially with cost of living, etc. And next slide, please. So this slide, we're going to just sort of, well, the next 2 slides are going to briefly talk about what the process is, because again, this is something quite new. So RPs are expected to publicise the right to shared ownership to tenants of all eligible properties, and they should respond to all inquiries. Now, we don't have any detail on where you're meant to publicise or how you're meant to publicise, perhaps on your website. I don't know. The advice on that, or the guidance on this point, is quite vague. Tenants will then contact the RP in the first instance to express interest, and then RPs must respond to tenants' initial contact within 4 weeks, stating whether their property is eligible. You then have 8 weeks from receipt of a full application to notify tenant of the outcome. And then if a tenant's eligible, RPs should arrange a home ownership meeting to discuss how the product works and associated costs. And I guess it's at that point where you'll be talking about affordability as well. Next slide, please. If following, so this is just, sorry, to talk about a few further details on the process. So if following the home ownership meeting, tenants confirm that they wish to proceed, RPs are RPs are to obtain a valuation within 6 weeks at their expense from a RICS valuer. Based on the valuation, the IFA will assess affordability and confirm to the provider the maximum share that the tenant can purchase. And within 4 weeks, the RP should then issue a formal offer notice, and the tenant has 4 weeks in which to accept, after which time the offer can be withdrawn. If the offer is accepted, the RP should check at that stage that the tenant is still eligible, and the tenant will then have 3 months from the date of acceptance to exchange contracts, and then a further month to complete. So there's quite a lot of information there on right to shared ownership, and as it's quite new, it's difficult to know exactly what the uptake will be and also exactly how the process will work. But those slides, detail the information that have been provided through the new Affordable Homes Programme. Next slide, please. So I'm going to briefly talk to you now about the new Leasehold Ground Rent Reform Act, how that affects leaseholders, but specifically how that affects shared ownership. I'm conscious of time, so I'm just going to try and get through these ones quite quickly. So the Leasehold Reform Ground Rent Act, which came into force this year. So what actually is ground rent? So it typically applies in long leases whereby the owner of the lease will pay rent to the landlord annually, as most of you already know. If a new lease is what's described as a regulated new lease, it will then mean that landlords can only charge a peppercorn rent, and a peppercorn rent is essentially nil value. Importantly, failure to follow the new law may require the landlord to pay a financial penalty between 500 and 30k. So obviously that's a big spread, but either way you want to make sure that you're you don't receive a penalty. Next slide, please. So what is a regulated lease and what is accepted? So generally a lease will be regulated by the Act where it's granted after the 30th of June 2022. It's a long lease of a single dwelling, and a long lease is something exceeding 21 years. It was granted for a premium. It's not an accepted lease, which you can see in that in the table as well, which we detail. The Act will not apply where a lease is not a regulated lease. Buyers and sellers enter into a legally binding contract before the 30th of June, and where leases are for community-led housing, certain financial products and business leases as well. So it's important to note it doesn't apply to commercial leases. Voluntary or non-statutory lease extensions, which can retain the existing level of ground rent for the remainder of the original lease period. And in a shared ownership lease where rent is payable on the landlord's own share and the peppercorn rent limit applies to the leaseholder's own share. Next slide, please. So importantly for this presentation, what does this mean for shared ownership? So shared ownership homes delivered through the new Affordable Homes Programme should have a ground rent of nil or at a peppercorn rent. Shared ownership homes do not follow the general rule for permitted rent, which applies to regulated leases. Instead, the permitted rent is in respect of the tenant's share of the demised premises, a peppercorn rent, and in respect of the landlord's share, any rent. This means that restriction on ground rent applies only to the shared owner's equity of the home. So you can still charge sort of specified rent, as is often defined in shared ownership leases, as normal. Rent on this share can still be charged subject to the requirement that the total initial rent must not exceed 3% of capital value of unsold equity at the point of initial sale. And there's encouragement for providers not to set total rent any higher than 2.75% of the value of the unsold equity at the point of initial sale. For the avoidance of doubt, you will be able to set ground rates for the equity that you retain, subject to the provisions we've just mentioned in compliance with the regulator's normal standards. So those are the end of my slides. So I hope you found that useful. We can pass on to the next speakers.
Thanks very much, Lee. Good morning, everybody. As Jonathan said at the outset, my name is Stefan Harris-Wright. I'm a partner at Burkitt's and I head up the construction and engineering team. And as Jonathan also mentioned, I'm going to be talking you through in this next section some of the key aspects of the new Building Safety Act 2022. So if I could have the next slide, please. So in summary, I'm going to cover three main areas, and those are initially a brief outline of the Act in terms of how it came about and its general content. I'm going to talk about a brief explanation of which parts of the Act are in force now, and then I'm going to finish off with a few key points about the impact of the Act on the social housing sector and why the legislation really matters for stakeholders in that particular space. So to kick things off then with a bit of an outline of the Act. So as I'm sure you will all know, the Building Safety Act 2022 is the government's response to the Grenfell Tower fire tragedy, which happened back in June 2017. And the Act received royal assent at the end of April this year. And essentially, the stated aim of the legislation is to secure the safety of people in or about buildings and to improve the standard of buildings. And the general view in the marketplace and amongst commentators is that the Act is effectively the largest kind of regulatory reform to the UK's built environment industry in around about 40 years or so. So really, really big news. The Act is a real beast, actually, in terms of its sheer scale. It's got 171 provisions, which are divided into 6 parts, and it's around about 260 pages or so long. So I've listed on the slide here the 6 main sections of the Act and the schedules. I suppose one thing to mention probably is that, interestingly, the Act consists mostly of amendments to existing legislation rather than being sort of entirely new standalone provisions, but we'll get into some of the detail of that during this section. A rather frustrating consequence of that is it's actually quite difficult to read. It sort of consists of lots of sections which say things like sort of delete these words and insert those words. So very much a case of needing a cold towel wrapped around your head to get into some of the detail, but I will certainly do my best. If I could have the next slide, please. So what's in force now? Well, you might be thinking that's a bit of a strange question to ask. You know, surely as the Act is on the statute book and surely therefore it's all in force now. Well, actually it's not. So one of the key things to note with the Building Safety Act, as is the case with lots of new large scale legislation, is that not all of the Act comes into force at once. And this is partly because the government recognises that whilst the building safety regime in this country is in need, excuse me, of significant change and improvement, also the industry needs time to prepare for the requirements of the new legislation. And that's why we're seeing a sort of staggered introduction of the Act. So this is probably a good time to briefly explain the difference between primary and secondary legislation, not to get too bogged down in black letter law and technical detail, but in a nutshell, primary legislation is the new Act itself, so in this case the Building Safety Act, and then secondary legislation is the statutory instrument or regulations which are required to actually bring the Act or sections of the Act into force over a period of time. So there have been 3 sets of Building Safety Act regulations introduced so far, and those are up on the slide here, those first 3 bullet points. As you can see, they all have really catchy titles, so I don't propose to read those out to you now, but you can look at those perhaps later on at your leisure when you receive the slides afterwards. But a consequence of these regulations is that they brought into force a variety of provisions within the Act, and I wanted to pull out some of the key ones and summarize those for you now. So just looking at the sort of bottom section of the slide here, one of the things which has been introduced is the idea of a building safety regulator, and the Act gave that position statutory recognition at the end of June this year. So I'm sure most of you will have heard of the Health and Safety Executive. Well, it's that institution, the HSE, which the Act names as the Building Safety Regulator. And the HSE in their role as regulator is going to have, well, it does have, as of the end of June, 3 main functions, and those are essentially overseeing safety and standards of all buildings. Secondly, helping and encouraging the built environment industry and building control professionals to improve competence, and also leading implementation of a new regulatory framework for high-rise buildings. And high-rise buildings are very much a recurring theme throughout the Act, probably for obvious reasons. If I could have the next slide, please. So continuing the theme then of what's in force now. So this slide lists out other key aspects of the Act which were brought into force by the 3 sets of regulations which I mentioned on the previous slide. I don't intend to go through all of those here, but I wanted to pick out a handful of what I consider to be key items for you and for this particular audience. First thing to mention is the first bullet point on the list actually, which is this definition of higher risk buildings, which is brought into the Building Act 1984, so that theme around changing existing legislation I mentioned before. So the Act effectively creates a much more stringent regime for higher risk buildings, and these are classified as residential buildings in England which are over 18 metres in height, or which have at least 7 stories, and which contain at least 2 residential units. So the requirements for higher risk buildings are numerous, but they include having things like having what we call an accountable person. So all higher risk buildings will require to have at least one clearly identifiable accountable person, and that person has numerous responsibilities, including things like registering the building with and obtaining a building assessment certificate from the building safety regulator before occupation of the building. Another thing that was introduced as part of this concept of higher risk buildings is something called a duty holder regime. So the Act gives a framework for all of those parties in the development sector who procure, plan, manage and undertake building work, and they are to be held under a duty to ensure that higher risk buildings are safe and compliant with building regulations. And the last thing to mention in the context of higher risk buildings is something called the golden thread of information. And this is really one of the main principles of the Act, being that there's this requirement on duty holders and the accountable person that I mentioned before to compile and maintain something called a golden thread of information, and that has to run through the life cycle of every higher risk building. And that golden thread is something which is featured in the press quite a bit. You may well have heard of it already. And the information here really has to provide an understanding of the building and the steps that will be needed to keep the building and occupants safe now and in the future. And that information has to be kept digitally, and it has to be made accessible to residents, importantly. Next thing I wanted to mention on this slide is the 4th bullet point down, which is around section 160 and the rights of social housing occupants to escalate complaints. So this section is basically designed to make it quicker and easier for social housing tenants to complain about landlords' poor performance to the Housing Ombudsman. So previously there were requirements for social housing residents who wanted to escalate a complaint to the Ombudsman to either wait 8 weeks, or they had to utilise something called a designated person. And you may have heard of a phrase, the democratic filter, which is what this relates to. And that required tenants to either contact an MP or a local councillor or a tenant panel before raising an issue with the Housing Ombudsman. So under section 160, that's all changed now, and effectively tenants can raise a complaint with the Ombudsman immediately after they've exhausted their landlord's complaints process. Final thing to mention on this slide is the next bullet point down, which is to do with changes to limitation periods under the Defective Premises Act and also the Building Act. So this is one of the aspects of the legislation which has received lots of attention in the press, and I'm sure you will have seen something about it already in your own reading. But just to summarise briefly what's happening here. So the Defective Premises Act 1972, obviously been on the statute book for quite a long time already, but that enables subsequent tenants and owners and anyone else with a legal or equitable interest in a property to bring a claim for defective work where the work renders a dwelling uninhabitable. So there's a couple of problems with this legislation. Firstly, it's a very high bar to establish a claim successfully. That hasn't changed, but what has changed is the limitation period for bringing claims under the Act. So previously it was 6 years from completion of the works. That's now changed. So for claims accruing before the date that the changes were introduced on the 28th of June this year, that period is extended retrospectively to 30 years. So claims can now be made as far back as 1990 for things that occurred in 1992, claims accruing back then. And for claims accruing after the 28th of June this year, there is now a 15-year limitation period. So really significant changes in terms of limitation around claims under the DPA. And then the second part of this is around the Building Act 1984. So apologies, there's a slight typo on the slide here. It should actually say section 38 of the Building Act, not section 30. But essentially the Act changes the Building Act, so there's a general right to claim damages where a person suffers harm due to a breach of building regulations. And this applies to any building in England and Wales, not just dwellings. Unlike the Defective Premises Act, the provision here doesn't have retrospective effect, but claims accruing after the end of June this year will have a 15-year limitation period going forward. One thing that's quite important to mention is that actually section 38 of the Building Act, so what I'm talking about here, hasn't actually been brought into force yet. We're looking at that position closely, as you might imagine, but currently there's no news on when it will be coming into force. So it's a case of watch this space on that one. And could I have the next slide, please? So the final thing I wanted to cover in the section was around some thoughts on the impact of the Act on the social housing sector in particular. Firstly, here in the context of housing stock and remediation. So I've got a few facts and figures for you here just to kind of set the scene, and some of these make for fairly kind of stark reading, I think. So the Ministry of Housing, Communities and Local Government runs an initiative called the Building Safety Programme, and they provide a publication called a monthly data release, which essentially gives information on building safety statistics in this country. So going back a couple of years, their April 2020 survey of all buildings in England estimated that the number of buildings over 18 metres tall, so captured by large chunks of this legislation, was 12,500. And of those, nearly half, so around 6,000, were of a social housing type. Coming forward in time a little bit, the Building Safety Programme monthly data release from April this year identified 160 high-rise social sector residential buildings identified as having the non-conforming and now notorious ACM cladding. And there's some information here on the slide in terms of work that's been done and progress that's been made to rectify that situation. So clearly a large amount of work going on in the sector, but the scale of the task is obviously significant and there is still some way to go. Could I have the next slide, please? So what else in the Act do I see impacting on the social housing sector in particular? Well, I anticipate significant changes to operations. Apologies, this is quite a busy slide, but I'll pull out some of the key points here. So first thing to note there is around approved inspectors. So housing associations are going to have to think really carefully about who they are appointing for building control approval on new developments, and there's a number of reasons for that. So the Act is introducing, for example, a new register of approved inspectors, and that's going to be maintained by the Building Safety Regulator. As I mentioned earlier, that's the HSE. Registration is going to be mandatory, and consultants can be limited, they can be removed, or they can be subject to sanctions as part of this registration process. And also there are big changes in relation to professional indemnity insurance requirements for approved inspectors. So significant things for housing associations and others in this space to think about. Next point down, complaints to the Housing Ombudsman. Well, we talked about that a short while ago. That's something which is now going to be permitted and effectively fast-tracked for tenants. And then thinking also about construction products. So there are sections of the Act that relate to a product which is effectively installed in, applied or attached to a building. This applies to all dwellings, and effectively a product is going to be illegal if it makes a dwelling unfit for human habitation. So sort of consistent themes from what I mentioned earlier about the Defective Premises Act. And there's going to be potential liability for personal injury, damage to property or economic loss. And that's quite a significant change, because previously the concept of pure economic loss, so loss which an individual incurs as a result of a sort of non-contractual claim, a tortious claim, used to be a type of claim which was excluded, but that's now brought into play by the legislation. So a person will be in breach of construction product liability provisions in a number of ways, including if they fail to comply with a product requirement in relation to that particular product, if they market a product with a misleading statement, or if they manufacture a construction product that is inherently defective. So lots of things for stakeholders in this space to think about in terms of, you know, who they're appointing to do their designs and whether those consultants are competent and taking into account all of these sorts of considerations when specifying materials and so on. So just in closing then, I suppose, on this section, it's a high-level canter through the Building Safety Act. Clearly there are some really significant changes for clients who are involved in the social housing sector, and lots of food for thought. And as I said at the outset, it's very much a moving feast. You know, the Building Safety Act, significant parts of it have come into play, others are still to come, so it's very much something that we all need to keep abreast of and keep close tabs on. So that draws my section to a close, and without further ado, I will hand you over to my colleague Clive, who's going to take you through the next section. Clive.
Thank you, Stefan. Hopefully you can all hear me. My name is Clive Adams, a partner at Burkitt's and head of the housing management team. I would like to talk to you this morning about the Social Housing Regulation Bill, and as we can see on the next slide, the bill was introduced as a direct result of the Grenfell Tower fire. Excuse me. It was first published just ahead of the 5th anniversary of the disaster, and if you recall, the Grenfell fire was on the 17th of June 2017. This bill was first published, saw light of day just slightly before that, beginning of June, and it was also as a result that during the public inquiry that followed Grenfell, a lot of the evidence that came out from residents in the tower was that they had been making repeated complaints about their own concerns of potential fire risks and health and safety risks, and the TMO that was managing the building was effectively criticised for not taking on board the concerns of residents when they were voiced. So that's a little bit of background to the bill, and what the bill does. It's one of these sort of kind of amendment legislation. So we'll all remember probably with dewy-eyed affection when the Housing Regeneration Bill 2008 came in force, and I'm sure no one needs reminding of that. But that, of course, bill, that act rather, brought in the HCA, the Homes and Community Agency, and brought in all the functions of the HCA as regulator. So what this bill does is effectively just add or change things within the Housing and Regeneration Act. The express aims of the bill is, and as it's quoted there, for more people living in decent, well looked after homes, enjoying the quality of life that they deserve. So those are the express aims of the bill, and as we'll see on the next slide, how the bill then attempts to do that. So it tries to do that through a number of different measures, which I'll go through. And one of the first things that it does, and in a way, probably the most significant changes in the bill, is the removal of the so-called serious detriment test. Now, currently, under the Housing and Regeneration Act, the requirements for the the regulator of social housing must have reasonable grounds to suspect that a breach of the consumer standards has taken place, and this has caused or could cause what's referred to as a serious detriment to an occupier of premises, and that has to be in existence before the regulator can then take any action. So by removing this test, this so-called serious detriment test, in effect it provides the regulator with a higher consumer standards proactivity, and essentially it gives the regulator more teeth. And we'll see on the next slide, this bill indeed does give the regulator a lot more teeth than it's enjoyed previously. So part of the objectives, it wants to, one of the bill's aims is to increase safety and transparency for tenants. In fact, the very first clause in the bill, number 1, provides to ensure registered providers act in a transparent manner in relation to their tenants. And this theme is then reiterated pretty much throughout the bill, this desire for providers to be acting transparently. So we've got increasing safety and transparency. First aspect of that, safety. So registered providers will be required to have a designated health and safety lead within the organisation. And importantly, it provides that this person has to be an employee of the provider, i.e. it cannot be outsourced and subcontracted. And although the compliance, the liability for compliance remains with the RP, so anyone that takes on this role will be happy to know that they won't be personally liable for any breaches. But as we'll see on the next slide, the role of the designated health and safety lead is a very, very important role indeed. So that person has to monitor the provider's compliance with health and safety requirements, assess the risks of failure to comply, and then notify in effect the management team, the directors, the CEO, or if it's an LLP, the members, the management team of the RP, of the risks that have been assessed, where there have been any material failures by the provider to comply with health and safety requirements, and must also ensure that the provider then has a program, has a plan for addressing those health and safety requirements and correcting them. So this person is feeding directly into the board, the directors of the organisation about the health and safety of the residents. You might think, well, what are the health and safety requirements? Well, in effect, the bill makes express reference to the Homes Fitness for Habitation, which added in the Section 9A of the Landlord and Tenant Act 1985. So all the requirements to ensure that the residents live in a home that is free from things like damp, mold, all the things that we saw in that tragic case in Rochdale. So this health and safety lead is going to be required, in effect, to ensure that what we saw in what happened in Rochdale never happens again. Next slide, please. Carrying on with the theme of safety, currently Section 122 of the Housing and Planning Act, which you probably won't be overly aware with because it only applies to lets by private landlords. So this is in the private sector. A landlord has to have a electrical safety check at least every 5 years. Now, for the social sector, whilst it is an obligation to keep electrical installations in repair, the Section 11 implied covenants, but you're not required to inspect them. So what the bill does is amend the Housing and Planning Act to put social landlords on a par with private landlords and requiring social landlords to carry out these electrical safety checks at least every 5 years. Now we know sort of currently with our social housing stock, we have sometimes difficulty doing our annual gas safety inspections. I think this is going to increase the burden, as well as doing the annual gas safety inspections. You'll be needing to do the electrical safety checks as well. So it may be that when you're arranging for once this comes in, when you're arranging for gas safety inspections, you'll have a gas engineer going in. You might try and also arrange with an electrician or something else, but I think it's going to then increase that burden of trying to get access. Next slide, please. So that was a quick overview on the safety. The safety and transparency. So transparency. The regulator can now, or will be able to, direct providers to collect, process and publish information concerning their performance as regards the regulatory standards. And the new powers is going to almost be analogous to what public sectors have under the Freedom of Information. So it's going to be this access to information scheme, the idea of which is then to enable tenants to request information from their provider. But unlike the Freedom of Information Act, that the scope of this access to information is just about the financial measures, performance and tenant satisfaction measures. The idea being that it then, through the publication or the requirement for RPs to publish information, enables then tenants to see how their landlord is doing and hold them to account. So it's all about these to enforce greater compliance with tenant satisfaction measures. Next slide, please. So one of the other objects of the bill is then improving competency standards. So this then requires the RPs to ensure that all its staff have the right skills, experience and knowledge to deliver what the bill refers to as a high quality service to residents. And as part of this, then the government has also announced that underpinning this driving competency standards, that the government or the regulator can hold, in effect, what's going to be almost like sort of Ofsted style inspections of providers where it's felt that that provider is underperforming, and these can be in as little as 48 hours notice compared with currently a 28 days notice. So very, very fast inspections where the regulator feels that an RP is not doing as it should do. Next slide, please. So they're also then, as a result of those inspections, and generally they're also then provided the power to issue what's referred to as a performance improvement plan, PIP for short, which then the RPs must follow under threat of financial penalties, i.e. fines, should they fail to do so. And again, I think this will then provide the regulator with a more kind of proactive enforcement tool than is currently available by the use of kind of voluntary undertakings. And again, as part of this drive for improvement of standards, there will be a new power for the regulator to issue unlimited fines. In fact, we've seen in the recently in case of the Rochdale Borough Homes, the Michael Gove announcing that their funding, their grant funding, is going to be withdrawn. They're not going to receive the money until Rochdale has been able to show that it's improved its standards. So again, the regulator really having some teeth here to make fines and pull funding. Next slide, please. And this is some of the I think some of the most hard-hitting changes. So currently there is the power under the Housing and Regeneration Act for the regulator to survey properties where the regulator suspects that the provider may be failing to maintain premises. Very, very little use power in my experience. And what the bill does is really ramp up that power. So it will give the regulator the ability to enter and inspect on 48 hours notice. And they can have the right to do this either without a warrant, i.e. we want to come and inspect on 48 hours notice, and if they're then not obtained access, they'll be given the power to go to the magistrate's court and obtain a warrant, enabling them to gain entry and by force if necessary. So really, really hard-hitting powers, affecting both the tenant, of course, because if the tenant doesn't comply with the written notice of access, then say the RP can go to the mags and get a warrant to enable them to get in. The bill will also give the regulator the power to then carry out emergency works. And with these, again, I suspect what happened in Rochdale may have driven some of these changes that were brought in through the third reading in the House of Lords. So these changes are very, very new. So where this power to carry out emergency works, this will arise, as we'll see on the following slide, in three circumstances. So condition one, that a survey has been carried out. Of course, without that, how would they know what state the property's in? Then condition two, following the survey, then the regulator is satisfied that the RP has failed to maintain the premises in accordance with its required standards, and that has caused an imminent risk of serious harm to the health and safety of one of the residents that are living there. And then condition three, that the RP has failed to comply with an enforcement notice served upon it by the regulator requiring it to carry out works. So if those three conditions are met, the regulator will then have power to carry out emergency remedial action. They will give the tenant 24 hours notice before works are carried out, and as with inspections, a magistrate can then issue a warrant if entry is refused. So the regulator's got really, really strong powers to get in to carry out works. Who pays for all of this? The costs are then passed down to the RP. Next slide, please. It then also the bill then also introduces these offences in respect of emergency remedial action. So again, sort of not only have you got the power for the regulator to get a warrant so they can force entry, but if entry is denied either by the occupier, namely the tenant, or by the RP, offences are created. So a person will be guilty of an offence if on summary conviction in the magistrate's court, to a fine up to £2,500 if they obstruct the person authorised by the regulator to exercise the powers of emergency remedial action. So if it simply won't be good enough for the tenant to say you can't come in, or my solicitors advise me not to let you in, etc., the regulator can force their way in, and if somebody objects, that person can then be guilty of an offence and fined up to £2,500. So some real bite coming to these new powers. Next slide, please. So the regulator will now have a legal duty, once this bill is enacted, will have a legal duty to publish a plan on its commitment to inspect the largest landlords, including details of how often these inspections will occur. And again, this was as a result of that part about publishing a plan on how regularly it will inspect the largest landlords. Was again one of the amendments that came in as a result of the report stage in the House of Lords on the 18th of October, so about 6 weeks or so ago. Next slide, please. So currently, the bill has been through all stages of the House of Lords. It's currently in the House of Commons. It's presently at committee stage, and that will happen effectively between now and the 1st of December. So committee stage is a line-by-line analysis. Then in the changes, will then go on to the report stage. Then it's got its third reading, and then it's the final stage of then receiving royal assent. Speaking to the regulator expects the bill to become an act before Christmas. So there's a real drive to get this on the statute books as soon as possible. Next slide. I think that's me done, and then handing over to Ian, if I may.
My name is Ian Rattenbury. I'm a chartered legal executive in the firm's housing management team. I'm going to go through one or two cases and updates over the last 12 months. And so if I can have the first slide, please. Now, I'm going to start with the case of the tragic death of Awab Ishaq. Now, we're all aware of this case. It involves the death of a 2-year-old boy who'd been living in his parents in a flat they rented from Rochdale Borough-wide Housing. I'll call them RBH. Now, Awab suffered a cardiac arrest due to respiratory failure, which had been caused by mold present on the property, which affected his airway. A building surveyor at Rochdale Council inspected the property after Awab's death and opined that it was unfit for human habitation without repairs being carried out. Now, it's beyond the scope of this presentation to go over the various factors leading to this tragedy in detail, but I'll briefly focus on one key issue, and that's the importance of identifying whether a property is in disrepair and or in such a state as to be unfit for human habitation, and if either applies, to take steps to carry out all necessary works as soon as possible. So as soon as you're aware of a problem, get in there and resolve it as soon as you can. Now, in this case, complaints had been made by Awab's parents since 2017, and in 2020 they had instructed solicitors, but for reasons we don't know, those solicitors dropped the case a few months later, and as this was a policy of theirs, they didn't inform RBH that they'd done so. To make matters worse, RBH had a policy of not carrying out any repairs regarding tenancies subject to legal claims until works had been agreed. If I can have the next slide, please. Now, RBH's policy is an obvious misunderstanding of the law. You only have to look at the pre-action protocol and you'll find that it says, and I quote, tenants must allow a landlord reasonable access for inspection and the carrying out of works in accordance with the tenancy agreement. It is also very, very well established law that if you're a landlord under a duty to keep a property in repair, you have the right to enter that property to carry out the repairs. I quote a case that backs that up. I also think it's difficult to see the benefits of having such a policy because, of course, if works are carried out as soon as possible, then it limits the liability of the landlord and it protects its interest in the property. Often you'll find that the tenant solicitors will state in their pre-action letter that access to carry out works will be refused unless or until works are agreed. Now, there is no basis in law for this, and it will, in my view, only serve to harm a tenant's position because a landlord can then argue this should reduce the damages awarded, and a landlord can use this to downplay the seriousness of the disrepair. And so one key lesson from this tragic case is that if it's suspected and then subsequently accepted that repairs are needed and whether or not a claim is being brought, it's important to gain access, carry out works promptly, and if access is denied, then an access injunction can and should be considered and often sought. If I can have the next slide, please. Briefly on fixed recoverable costs, or FRC. In November this month, the Ministry of Justice announced it will be delaying the introduction of FRC until October 2023. Now, the current regime only applies to personal injury cases with a value of £1,000 to £25,000. And that has meant that for those lower value personal injury cases, they are no longer very profitable for no-win, no-fee lawyers, and that's why they have migrated into our sector, or at least that's one reason why. But this seemed like good news for landlords. The proposal was to extend the FRC to all areas except for a few limited exceptions. Now, the hope was that the introduction of the FRC regime into most areas, including housing disrepair, would have been a helpful change for local authorities and housing providers. Instead of being faced with inflated cost claims from claimant lawyers, there could have been certainty as to what level of costs the court might order in a case, rather than the drawn out and unpredictable cost assessment process, and also B, perhaps a significant reduction as to the level of cost that could be recovered against a defendant landlord. Now, the latest from the Ministry of Justice is that this delay is due to more time being needed by the sector to adjust to the changes. That may or may not be true. There's certainly no current indication that it will be shelved for good, but it is a serious concern to local authorities and housing providers, and it's at the moment a relief for claimant lawyers. Could I have the next slide, please? I will skip through this one because I see we're very, very short on time. It's all to do with the damages you can claim in disrepair and whether the 10% uplift that was brought in after success fees were ended applies to disrepair. It will suffice, because of the shortness of time, to say that the uplift does apply. Can I have the next slide, please? This is an asset case. It's Asset Hold Limited versus Adam and 14 others. It goes back to section 19(1)(a) of the Landlord and Tenant Act of 1985. Tenants only liable to pay service charges to the extent they were reasonably incurred, and that's the crux of this matter as well. This case involves Asset Hold. They're a freehold owner of a building. They sought opinion from fire safety consultants. The fire safety consultants set out a number of problems affecting the building and advised this was an intolerable risk to residents. And so prior to carrying out any works, the consultants had advised that a waking watch should be put in place in order to provide a safe evacuation in case of a fire. Now, much later on, the second consultants advised that a waking watch was not needed. So Asset Hold put in place a waking watch and tried to recover the costs of this, which is circa $28,000 a month from their lessees, who challenged this in the first tier tribunal. The first tier said that as the waking watch wasn't needed, the costs were unreasonably incurred. Asset Hold appealed to the upper tribunal, but only for the costs of the waking watch for a 1-month period, rather than the entire duration, which ran from March to November of 2021. The upper tribunal did allow an appeal because it held that Asset Hold acted reasonably in following the initial advice of the need for a waking watch. And so the service charges it sought to recover for the initial 1-month period was therefore reasonably incurred. Can I have the next slide, please? This is a very, very popular case at the moment, particularly amongst defendant lawyers. It involves very, very strong criticism of a housing association for its handling of a case in which it sought an antisocial behaviour injunction against 2 women, a mother and daughter. Both women made counterclaims for discrimination contrary to the Equality Act 2010. And the case revolved around allegations of abusive language to local residents, loud music, and at its heart, allegations of the daughter continually filming the road she lived on and her neighbours. Now, there were hundreds of allegations in this case, and so the court said, no, we're going to reduce it down to 6 sample cases to see whether there was a pattern of antisocial behaviour. But the court found that each of Rosebery's witnesses had either exaggerated or embellished their evidence, and that only one of the complaints had any validity. Now, expert evidence provided to the court suggested that the daughter's obsessive filming arose due to obsessive compulsive disorder, was not malicious or perverse in its intent, and that making an injunction would cause more anxiety and inflame the situation on the ground. It was considered that Rosebery's witnesses should have shown reason and understanding when dealing with the daughter, and that Rosebery could and should have used specialist expertise to try to address the problem rather than just going ahead and seeking an injunction. The injunction claim was dismissed and Rosebery ordered to pay a whopping $27,500 in damages plus costs, which probably exceeded that. In the words of the judge, if ever there was a case in which the social housing provider needed to acknowledge, become familiar with, and then discharge the public sector equality duty with vigour, it was this one. Next slide, please. This one, I think, again, because of the time constraints, I will skip through. In essence, it involves the right to request a review at the end of a fixed term of a flexible tenancy when you have a 21-day time limit in which to make a review. This person, Ms. Kalonga, didn't request a review within the 21-day time limit. And the consequence of that was that she lost her right to review. And also, the court held on appeal that there was no power either. So always important to see what the particular right to review contains. And if it says must, and there's no room for wriggle, then must means must. If I can have the next slide, please. This is a homelessness application, Roe versus Haringey, and it's all about whether and to what extent the provisions concerning statutory overcrowding set out in Part 10 of the Housing Act of 85 assist applicants to argue that although they haven't got accommodation available to occupy, it's not reasonable for them to occupy that accommodation, and they're therefore homeless as a matter of law. Now, when looking at statutory overcrowding, there are two standards, room standard and space standard. Under room standard, a child under 10 is disregarded. Under space standard, a child aged over 1 but under 10 is included as a half person. And both tests are applied to what we describe as, and I quote, the dwelling, which is defined, and I quote, as used or suitable for use as a separate dwelling. Now, Ms. Rowe lived with 2 children aged under 10 in an HMO with sole use of 1 room and shared use of communal facilities. She presented as homeless to the council on the basis that her accommodation was within one of the definitions for statutory overcrowding, but the council rejected this and its decision was upheld on appeal to the county court. Then Ms. Rowe appealed to the Court of Appeal on the basis that when considering the dwelling, the question was not whether the room she rented was overcrowded, but whether the HMO as a whole was overcrowded. If this were correct, it would mean the council needed to take into account all other occupants of the HMO before deciding there was no overcrowding. And as the council hadn't done so, it's correct, would show that the council hadn't proved there was no overcrowding. Now, although the council had made a separate error of law, and so it needed to carry out a further review, the Court of Appeal decided that the appeal should proceed because the same issue would come up in the further review. Now, the Court of Appeal rejected Ms. Rowe's appeal. It held that the definition of dwelling only included the room let to Ms. Rowe and her children. She did not use the whole of the HMO as a separate dwelling, nor was the HMO suitable for use as a separate dwelling. If I can have the next slide, please. This is the case of Biden versus Waverley, BC. It involves the case of a trans woman who brought an appeal. She challenged an offer that was made by Waverley in discharge of its duty to her. Now, Waverley had accepted a duty to Mrs. Biden and offered a property to her, which was around about a mile from her previous home. But Mrs. Biden rejected this because she contended that she'd suffered abuse and assault owing to gender reassignment and was too frightened to live in the property because she was unfamiliar with the area. Now, Mrs. Biden claimed the protection of the public sector equality duty, and that's buried away in Section 149 of the Equality Act, the duty to have due regard to the need to eliminate discrimination, harassment and victimization, advance equality of opportunity between persons with protected characteristics such as gender reassignment and others. Now, on review of this case, Waverley spoke to a local PCSO, but came to the opinion that there was no evidence of any particular problem in the relevant area regarding hate crime towards persons who had reassigned gender. And so Mrs. Biden's review failed, and then the county court dismissed her appeal. Mrs. Biden appealed and argued that the public sector equality duty meant that the reviewing officer at Waverley should have made inquiries with an LGBT liaison police officer and not just a PCSO. The Court of Appeal described this argument as absurd, my words not theirs, and held that the reviewing officer knew of Mrs. Biden's protected characteristic, had made proper inquiries, and there was no reason to believe that different information would have been provided by an LGBT liaison police officer. In essence, this is all about the scope of the inquiries that an officer has to undertake. And there is a case going back years which says that they don't have to undertake a CID style investigation, which I think this case just simply confirms. If I can have the next slide, please. This is a case involving London and Stokes. It concerns a tenant who was fraudulently granted a tenancy agreement by officers of the landlord. Now, two officers of L&Q had engaged in a course of action in which they'd been identifying properties where the tenant had died and were letting these properties outside of the provisions of an allocation scheme. Now, Ms. Stokes was one such tenant, and when the fraud came to light, L&Q brought possession proceedings, claiming that their employees had no authority to grant the tenancy and Ms. Stokes had conspired in a fraud. Now, the county court dismissed the possession claim on the basis of the law of ostensible authority, which for the uninitiated means that if the principal, in this case L&Q, has an agent, the two L&Q officers, and that agent is authorized to act for the principal, if a third party, Ms. Stokes, acts in good faith in that authority, then the principal, L&Q, is bound by this. And so it was considered by the lower courts that Ms. Stokes had acted in good faith, and so L&Q were bound by the actions of those two officers, and an appeal to the High Court was dismissed. If I can have the next slide, please. This case involves a tenant ceasing to occupy a property as her only or principal home, and then a subsequent defence to a possession claim brought against the tenant's daughter, who'd remained in occupation after the tenant had ceased to occupy. The tenant is Dorothy Maley, who I'll call DM, who'd lost capacity and was moved to live in a care home. The property was a 3-bedroom house, which had been let to DM since 1965. And the tenant's daughter, Marilyn Maley, MM, had lived with DM for over 50 years. After DM left, MM was still in occupation of the property, and in light of the shortage of social housing in the district, Dudley served a notice to quit on DM and sought possession against MM. Now, DM subsequently died 3 days after Dudley had commenced possession proceedings. If DM had died while living in the property, MM would have been entitled to succeed as a qualifying successor under Section 87 of the Housing Act. And as DM, while still alive, didn't have the capacity, she couldn't assign to MM as a qualifying successor. Now, the main thrust of MM's defence to the possession claim was that A, eviction would breach her right to respect for her home, contrary to Article 8 of the European Convention, and that Section 87 of the Housing Act was incompatible with the prohibition against discrimination. So that's in Article 14 of the Convention. And that was, she argued, in that Section 87 treated persons whose parent had been required to move out of a property differently from persons whose parent had died at home. If I can have the next slide, please. MM also defended the possession claim on the basis that it was unlawful because Dudley had not followed its own letting policy and given MM a right of review. But the court dismissed this claim mainly because MM had not properly participated in the review that they were conducting, and the court considered MM's case did not meet the high threshold for cases of this nature. Now, the court held that the Article 8 defence must fail, and that was because Dudley were pursuing a legitimate aim, i.e. demand was high for properties and the property was under-occupied. So Dudley were held to have legitimately sought to exercise their housing management functions, and on top of that, they'd clearly been willing to offer MM some new accommodation elsewhere. This was the case even though MM was 68 years old and presented with mental health problems, and so eviction would have probably had an adverse effect on her well-being. As for the Article 14 defence, this also failed because the court thought that MM didn't have the status needed to bring her within the protection of Article 14, i.e. being the child of a person who lacked capacity, was too vague and unclear to amount to a status. Further, that there was no analogous persons to whom MM could be contrasted so as to show that she had been discriminated against. The court also held that if this was incorrect and there had been discrimination, that the discrimination was justified. Again, the shortage of properties in the area and the size of the property are factors here. And that is my final slide, and so I think I've ended with 2 minutes to spare for any questions.
Thank you very much, Ian, and also thank you to all our speakers this morning. We have covered a lot of ground, detailed ground, and happily the session has been recorded, and we also will distribute the slides to all of you who attended this morning. Now, we do have a Q&A session. We did start the webinar all 10's way, more or less around then. So what I'll do is hold the Q&A session to round about 20 to 12. So we have 10 minutes or so together, and so that you can ask questions and the full panel has an opportunity to answer. The full panel is appearing on screen as I speak, and I'd like to take this opportunity to again welcome two members of the panel who haven't yet spoken this morning: Kevin Edwards, who is a legal director in the team, and also Catherine Hodds, who is an HR expert. Thank you again for joining this panel this morning. We do have some questions that have come through, but I would like to start with you, Kevin, if I might. If you could just explain to the wider audience a little bit about yourself and your background, but also reference to Clive's comments about this threat of essentially this commentary of both the Secretary of State and the regulator about withholding affordable home funding for RPs who are deemed to have breached consumer protection conditions, and in particular in this case the standards that were referenced earlier. Just your take on that threat. Thank you, Kevin.
Yeah, of course. Thanks, Jonathan. Hello, everyone. I'm Kevin Edwards. I joined Burkitt's three weeks ago. I'm a legal director based in Cambridge in the social housing development team. I've got 13 years worth of experience in the sector now, both in-house at Homes and the Communities Agency as was, and in the private sector more recently. So this question about the withholding of funding, I was at Homes UK conference in London last week, actually, where this point was raised and discussed. My view on it is basically that it's not quite the right approach. Now, taking from the start, obviously you can understand there's a need. The government feels a need to do something, to show that it's doing something, because it's been such an appalling tragedy. But I think it has the sense to me of a slightly knee-jerk reaction. I think it would be counterproductive if that funding were to be withheld in the manner that Michael Gove has suggested. I think that would actually put more lives at risk, not less, because the providers in question would then be struggling to meet their existing obligations, let alone future ones that arose. I think the actual solution is already out there as well. It's the regulators' role in ensuring that the governance of the RPs is solid. So what an RP needs to do, they need to have their board needs to be strong. There needs to be informed as to this procedure. So they need to have outlined a process for inspecting these properties. They need to be having oversight of that process. They need to be clear, having visuals of that board, having sight of it. A lot of RPs, I'm obviously on an RP board myself as well at Great Wall Homes, and a lot of RPs, they don't have that sight, that oversight. They'll have reports from their exec, but they won't have that detailed involvement in most matters, because you have to devolve some of it to the exec. That's their role. But I think in this case, this aspect, you'd want to see a rolling programme. You'd want regular updates of these inspections, and then once that inspection regime has been concluded over all of your properties, you can then continue having regular updates on it as they progress, and just keeping on top of that approach. The solution for the regulator, of course, is if they don't see any evidence of that, or if there's consistent failings, they can use the downgrades of governance. So the G3 or G4 downgrades is the way to really affect a provider. And obviously, if your downgrade is G4, often then that implies the regulator will step in anyway and take control in those circumstances. But I think while the threat to reduce funding is obviously intended to be used as a stick to say, get yourselves into shape, I would hope that he would never actually use that approach, because I think it would be counterproductive.
Thank you very much, Kevin, for that comprehensive answer. I think there will be comments on your answer, I'm sure, as the Q&A proceeds. Catherine, if I could ask you to give us all a little bit of background about what you do, and also, again, Clive and Stefan mentioned the improving competency standard, this idea of housing associations and local authorities being responsible for improving and upskilling their staff in relation to the work that they perform and functions they carry out. So your take on that would be something of interest.
Thanks, Jonathan. Hi, everyone. I'm Catherine Hodds. I'm an HR consultant at Burkitt's, joined the team on the 1st of September. Prior to that, I was Group HR Director for Circle prior to the Clarion merger, and then more latterly Group Director of People and Culture at Saffron. I was really interested to hear what was said about increasing competency. I know that housing associations are not cash rich necessarily, but there is an obligation on all of you in the light of this to put even more focus than you already do on increasing the learning and development that you put into your staff. And I think the thing that really struck me was how do you evidence that? And I think more and more you're going to need to be able to show, as schools do, exactly what training you have carried out and how that plays into that increasing performance. In order to do that, you need to know where your performance is and how you get it from where it is to a higher performing level. Part of that will be learning and development. Part of that will be coaching and mentoring. Some of your evidencing will need to be in place to make sure that you have got robust appraisal systems that evidence what you are training people on, what they know about, what their skills are, regular reviews of their skills and experience. So I think one of the things that I would perhaps think about is doing regular reviews that actually look at not just how did you do your job this month or in the last quarter, but what's next? How do you keep abreast of that and how do you evidence it? There's some brilliant online appraisal systems that I think perhaps would be worth housing providers looking at. Most of them aren't particularly expensive. More and more check-ins, quarterly reviews, as much evidence as you can get. And I think, again, if you don't already do this, oversight for the board to make sure that they are aware of how you are putting those actions in place. It's pretty much sensible management of what you probably are already doing, but making sure that your evidence is really, really robust so that you can prove it when they come and land on you with 48 hours notice, which I'm sure will strike fear into the hearts of many an HR director over the next few months. But if you're doing your jobs well as leaders and as managers, you should have the majority of that anyway. I just think a sharper focus on evidence would probably be the point of where you need to focus.
Thank you very much, Catherine. Very interesting, indeed, dare I say, very challenging in content for our clients and for the wider audience. I have a question, excuse me, for Sarah. Sarah, you talked earlier about the changes, the fundamental changes that the new shared ownership model lease ushers in. What's the take-up been like amongst RPs in your view, and where are the real sticking points, do you think?
Well, I think up until now, it's not really been the case that the mandatory kick-in has happened. So they've had the option to use it. And like I said previously, what we found is that clients are using the term of the new lease, but not necessarily the other provisions. And that's more just, I think, about getting organised and putting the measures in place that are needed internally before they're able to offer that. So the key information documents, there's work that needs to go into those. And you almost don't want to roll them out anyway until they're in the final format that you're happy with. And again, in terms of the repairs, there's a lot of behind the scenes work that needs to be thrashed out first as to how that is going to work in practice before that's rolled out. And I think, as with anything, if you're given the benefit of time, then take it. And I think, yeah, providers are just using this time to get themselves familiar with what they need to do. And then when the mandatory kick-ins happen, then they will have to provide those leases, and they'll hopefully be in a better position to do so.
Thank you very much, Sarah. And on the subject of time, Stefan, you mentioned the various transitionary arrangements that the Building Safety Act ushers in. If you could provide the audience with maybe your top 3 tips in terms of what they should be looking at first during this transitionary period, what would they be, do you think?
Sure, thanks, Jonathan. I suppose it comes back to some of the things which I mentioned during the presentation, really. So thinking about things which are happening now, the building safety regulator is clearly something that's really significant. So I mentioned about the fact that responsibility has been handed to the health and safety executive, clearly a well-established and well-known institution within UK construction field. But they're the body who are going to be, the real sort of kind of invigilators, if you like, of lots of the requirements of the Building Safety Act. So having a very close look at what the Building Safety Regulator is going to be doing and their powers, and also, understanding the penalties for failing to comply with their requirements is going to be really key. And I'm sure lots of stakeholders, this legislation has been a long time in the making, clearly. So we've had a relatively good sort of visibility on what's coming, and so I'm sure lots of the audience will have been engaging in those preparatory sort of stages. But yeah, absolutely right to keep on top of all of that. And then undoubtedly clients will have been reviewing their existing housing stock, so thinking about whether they fall into the category of high-risk buildings, scouring their records to find out what information they have available in terms of the design and construction of those assets, and checking to see whether they comply with the new requirements is obviously going to be key. And again, I'm sure that's something which has been going on and will need to continue for some time. And I suppose thirdly and finally linked to that is thinking about these changes to the limitation periods under the Defective Premises Act and the Building Act. I mentioned the DPA changes are already in, and they brought in that retrospective 30-year limitation period going back to 92. Still waiting for the Building Act changes, so that the claim that can arise under breach of building regulations. But we have been approached by lots of clients in this space and other parts of UK construction who have been aware that there are problems with assets and sort of put them on the shelf because they felt that they were stymied by the 6 or the 12-year limitation period. And obviously these changes are reigniting the ability to review all of those and think about whether actually there is benefit in reviewing those carefully and thinking about making a formal claim.
Thank you very much, Stefan. And looking at the time, it's now 20 to 12, and I would like to thank all of you for joining me this morning, and thank you to the wider audience for your participation too. We have covered a lot of ground, a lot of detailed ground, and I hope that you found this morning's webinar interesting, useful and insightful too, of course. The session is being recorded, as I mentioned earlier, and will also circulate the slides to all attendees. So all that's left for me to do is to say thank you again I do hope that you found this useful, and until the next time, thank you very much and goodbye.